So we have Mads Football Edits is asking a question. He says, "What are we talking about here?" So what we're talking about is the uncontested divorce process in California. If you have questions about that, that's what I specialize in. And Patty's answering financial coaching questions. So if you have questions about, I don't know, Patty, what kind of questions are you going to answer today? What are you open to?
I'm open to
Just open?
whatever. I'm
Yeah.
open. Yeah, it's I'm not an advisor anymore, so I can't give advice, but I can certainly ask me something, and I will tell you what
Make
I can
something up.
answer. No, I won't make something up.
Buy Bitcoin. No, we're not going to we're
No,
not giving that.
no. Boy, Tim, you're just full of advice today, huh?
You're right. So to answer your question about the support, yeah. So the child support order is part of the final settlement agreement, and that if there is child support, it will state how much that is, and then the parties sign that, and the court signs that, and that becomes a court order from the court, obviously, because the judge signed it. So if in your question about if support is not paid, it can get complex. So there is that order, it is due. But what if someone doesn't pay at all or stops paying us, the full amount? Then you have to go back to court and say, "Hey, judge, they haven't paid," and the judge can then take some other action. One thing that can be done, and so it's supposed to be mandatory, but the courts don't make it mandatory, is having a income withholding order filed with the case. That's the best way if there is a W-2 employer or W-2 employee that you can attach the support order to their wages. So it's paid directly from the employer. Then it goes to child support services. I think they give them like a debit card, and then they monitor the collection that way through child support services. Even the clients I have that have child support built into their divorce, they are not wanting there to be a withholding order. They just don't want their employee. It's kind of if you have a smaller employer, they know you're divorced now. They know there's a withholding order, and they have to cut a separate check to child support services or however they do that, or direct deposit. So I can't remember the last time I've filed a withholding order on one of our cases for that purpose, because again, for the very nature of what we do, being amicable. But when I worked for the courts, and then I worked for an attorney 11, 12 years ago, almost every case that had support, whether it was alimony, spouse support, child support, or both, had the withholding orders attached. And it's not wrong to do. The courts say it's mandatory by the simple fact that they're not making it mandatory. I'm telling our clients you don't have to have it, and most don't want it. Even both spouses, they rather just have, he or she's going to Zelle me the money, or they keep one account joint and they just transfer the money into that account. But doing this amicably is completely different. Even when people call me, they'll say, "Oh, my situation's different. We agree on everything." I said, "Well, that's what I'm here for." You and the other 20 people I talked to this month. So
yeah, that's great.
Yeah. Spousal support, big issue is, so the child support, just to kind of end on that, is you don't have to have it if you guys don't want it. If you agree you want to reserve it, that can be done. Special language has to be inserted into the settlement agreement to do that. If you're trying to do your own divorce and you don't, and you think your divorce is easy because let's just say there's no child support, that actually complicates the divorce, because that goes against the grain of the court policy where it needs to be mandatory. So it actually, I get what they're saying when they say it's amicable, but that actually they will never know how to get, if they're trying to do their own divorce, they will never get it through, because the court's not going to tell them that you need the special language. That essentially is a few paragraphs of language. They will cite, I've seen it. They'll say, "Hey, Tim," they'll hire me and they'll say, "Hey, I got this reject letter because they said we can't do no child support." And they said, "We need to reference a particular family law code." And so you can't just say, "I'm referencing this code." There's a whole paragraph that goes into that. Same with the spouse support, which I was going to talk about next. There's a whole paragraph of waiver language if you want to terminate jurisdiction over spouse support when you've been married longer than 10 years. And again, the clients trying to do their own divorce will not ever know what that language is. So if they're trying to terminate spousal and they agree on it, the court will reject that every time unless you insert this special waiver language. I get asked about so much. I mean, that I'm thinking of creating like a PDF in Canva with the language as an attachment and like selling it for $10.
There
Like,
you go.
you want to do your own divorce? Fine. You're going to need this. Here's the, I have it all written up for you. Pay for the download, do your own divorce, go at it. So I've had that as a note on my desk for like 6 months.
That's a great idea though, for those that want to do it all themselves like that. Yeah, very useful. And a bargain at $10.
Yeah. So I guess the other thing to talk about with spousal support is that it's no longer a deductible expense. It's also not claimed as income to either party. So I guess that's a benefit to the receiving spouse. They don't have to claim it, but the person paying it can't deduct it anymore. I want to say 5 years ago or so, that changed, and the only ones that are able to continue to claim and or deduct is if their judgment was completed before that changed. So they're like grandfathered in.
Yeah, I think it's been about 5 years. I think
Yeah,
you're right.
does that sound familiar?
Yeah.